Here.
Mr. Katowski?
Way over here.
Dr. Phelps?
Here.
Mr. Thorson?
Here. Can we all stand for the pledge of allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Can I have a motion for approval of the agenda? So moved. Do I have a second?
Second.
Discussion?
Yeah, I just have one quick question. Do we have minutes we're supposed to be ready for this one?
Your minutes will be approved at your next regular meeting. And if you want to see them, I can give them to you, but usually they're approved at your next regular meeting. So you'll have 3 minutes to approve in July.
Okay, any more discussion on the agenda? We're good? We can't add anything, in just as record, we can't add anything to this agenda, but we can certainly delete some items, but everybody's good? Okay, roll call?
Mr. Douglas?
Yes.
Mrs. DeTore?
Yeah.
Mr. Katowski?
Yes.
Dr. Phelps?
Yes.
Mr. Thorson?
Yes. I want to just start off by explaining tonight's meeting. Tonight's meeting is a special meeting for appropriations. And it was also a meeting that I had sort of alluded to, a promise from the community that we would address some items that had been outstanding. Some of them being legal bills, some of them being some of our protocol, even right down to why did we make some decisions regarding our administration. So I've invited John Kardursky, who has been our attorney, has it been 22 years, John? 23 years? 22. 22 years, and is one of 6 attorneys that we employ, but we've probably relied on pretty heavily, as other boards have this year, to advise us and to sort of make sure that we're navigating the waters correctly. And I've asked John to sort of prepare some items. He and I discussed. There were items that were addressed in news media or questions that were asked of us. Things like, why is open enrollment, do we not offer grandfathering? And one of the ones that was a little bit more near and dear to my heart was, why are we spending so much money legally, and what's the forecasting of what that will look like? So, John, I know that we have a few things prepared. I'll give you the floor.
Thanks. I think a pretty safe assumption in the past couple months, this has been a pretty active Board of Education, very active community. A lot of documents have been circulated. So I think what I'd like to offer tonight is a perspective. While I'm not really going to entertain a lot of questions, I just want you to know that. I'm just going to say what I think are some responses, and then I think we can go from there. I know Mr. Katowski had a few issues he wanted to talk about as well, and plan to incorporate those in at the same time.
Great, thank you.
First issue I think that may be brought up is the use of the prosecutor. I think we probably want to be talking about the role of the county prosecutor. Great prosecutors, going back all the way to the Honorable Judge Forrest Burke, going to the Honorable being chosen in the first grade. The prosecutor has a statutory duty to assist you when called upon. One of the things that I think we need to keep in mind is who in the West Geauga School District Board of Education has that responsibility to contact the prosecutor. Since I've been here, superintendent number 6, that's always been the responsibility of the superintendent and or the treasurer. I don't think it's fair for board presidents to wear the mantle of contacting the Geauga County prosecutor. And so I think as a solution to some of the issues, my first recommendation would be that Mr. Nutter and Ms. Jones set up an appointment with the prosecutor's office. Let's find out exactly what services for the 2014 calendar year and beyond they'll provide for you. Let's find out what services they may not be able to provide for you with their limited staff. I think that's the way it's worked for 20 years. The recent exception to that as to why the prosecutor wasn't contacted in the past year and a half or 2 years, I think I'll have to ask your superintendent and the treasurer. But again, I would want to caution, I don't believe it's ever been the situation where the board president or vice president, him or herself, goes forward and contacts the prosecutor's office. While we're talking about that topic, I prepared a simple one-page about the legal fees along those lines. And again, I circulate this for purposes of perspective. There's been allegations that this current Board of Education uses outside law firms and doesn't use the prosecutor. What I'm passing to you is a list, and thank you, Shauna, for the data, from 2000 to 2013. And when you go through that list, I think you'll see that we spent almost $300,000 in 13 years in outside law firms. So, and that's in addition to the work that you have provided for by the county prosecutor. What I've listed there, of course, are the dollar values and the president and the vice president during those relevant years, so you can kind of get a flavor of responsibility. But again, I would not look historically to the president or vice president of the board to contact prosecutors, or for that matter, to determine which of your 7 law firms that you deal with based on issues. I would think that going forward, to try to provide solutions, you would direct your superintendent and treasurer, when appropriate, to determine what role the county prosecutor's office can and should play as we go along through that. One of the issues that I think I also want to bring out when you look at the amounts, these are of course all of the law firms that you've dealt with on the basis of our accounts payable register for these 13 in terms of the aggregate. Oddly enough, based on your district retention policy, you have, with permission, destroyed your vendor records prior to 2000. Fortunately, I hack rat that I am. I have from 92 when I started representing you to 99. So if you have an interest in the previous 7 years, I have that information as well. I think this kind of makes the point. The other thing, too, I think that you want to take a look at is in my correspondence, I think the superintendent and others, there may not be an understanding of the 7 law firms you deal with. There may not be an understanding of who does what, who's called upon to do what services. I know, for example, that some of you might be surprised that you've already spent $14,000 this year in a law firm other than mine, and what exactly those services provide. So I think one thing that your superintendent and treasurer can do going forward would be perhaps to give you a little bit of handle. They're going to be the ones contacting legal counsels for purposes of advice. And I think you'll want to know what firms are being dealt with, the rates of those firms, and or whether or not the prosecutor's office should have been contacted prior to asking outside counsel. So when we talk about, again, the use of legal fees, I think the last point I want to make, and then I'll move on with the prosecutor's office. I know there have been some public record requests of not only our district, but the other 6 local school districts in Geauga County in terms of the dollar value of the outside counsels that they've used in the prior years. If you haven't done that and you have an interest, I think you want to take a look, and particularly the big 3, West Geauga, Chardon, and Kenston, in terms of the dollar values that they spend in outside firms. And again, in addition and not in lieu of the county prosecutor's office. The next topic that I want to address, I think, first some of the questions that have been raised to me, is discussions in prior years with board members and president. Again, I think there's some confusion here, so a little bit of perspective, and I apologize if I make it sound too much like a historical perspective. Until about 6 years ago, so from 1992 to perhaps 2006, 2007, it was rare that I heard from a board member. Through the 6 superintendents that were here, County Mr. Nutter, almost exclusively contact of legal counsel, at least in my office, was done via the superintendent and or treasurer, or perhaps the director of special ed. If anyone else called me, it was typically by permission. I think that changed, in fairness, after the 2007 election. I think that it changed that in 2007, there were more independent challenges to the operation and governance of this board. I think after the 2007 election, there were more challenges in terms of the operation of the office of the superintendent, and more questions being raised. I believe that there were some issues where perhaps things that certain board members from that point forward received from administrative staff, they thought perhaps may not have been appropriate, perhaps may not have been the exact way that things were being governed. So what started was conversations directly from board members to at least my office and perhaps others, verifying and double checking what they were told by administrative staff. That's as candid as I can make that. Those conversations started with simply one board member. Eventually, we had a board president involved, of course, to find out exactly what it is that the one board member heard. And I think we were off to the races from 2007 on. And we have continued where board members have felt that they can call legal counsel, and I presume they call other legal counsel, although I don't know that for a fact, in terms of issues that are important to them. While under attorney-client privilege, I can't tell you the specific reasons and the specific advice and questions. I can tell you that from 2007 on, there have been three main topics in terms of what's been given to me. The first topic, of course, are issues of governance of the board, operation of the board, both roll call motions, legal issues pertaining to non-renewal, statutory timeframes, and deadlines. The second is questions regarding the operation of the superintendent's office. Here's what I was told. Is this true? Is this untrue in terms of legalities of operation? And then finally, we started getting the sprinkle, if you will, of issues pertaining to other board members. Emails from other board members, conduct from other board members. So this is not necessarily a new issue. It's been around since 2007, although I think it peaked in the last 2 years, calendar year 2012 and calendar year 2013. In fairness to the 2014 board, the issues that have been presented to me, again, without getting into specifics unless we're into an executive session, I can tell you that the topics were different. There have been, at least to the best of my knowledge, very few discussions with me pertaining to other board members. It's more of the governance of the board, issues of agenda development, issues of protocol, issues of Robert's Rules of Order, issues of governance that I think you would expect when you look at our 2014 board, and none of you have had any leadership experience as either president or vice president of the board. Ms. Orson, you've had your crash course now. You've been president, I think, a month, and Ms. Torrey, I think you've been vice president for 5 months. So perhaps a month or two from now, I'll be able to make that claim. But under Mr. Kilroy and Mr. Torrey's leadership, there are an awful lot of questions pertaining to the operation of the board. I hope you realize that it's unusual in an election for both the current board president and vice president not to be there for continuity for the following year, either choosing not to run, or rather, in this particular case, choosing to run but not being reelected. So, and again, there are solutions to the contacting of the board members. First of all, let me say that I've had some experience in dealing with your superintendent, Mr. Nutter, and the good news is he hates lawyers. I don't say that sarcastically. For him to call me, he faces actually a show of defeat. So if you have questions pertaining to the governance, the operation, or statutory issues, you don't need to call one of your 7 law firms. You can simply ask Mr. Nutter. If he doesn't know the answer, I suspect I might hear from him. I dare to build in with my response, of course, and I check. But I think that's important. I think with the direction that you're going now, I believe that the phone calls have stopped, the emails have stopped, and of course, Mr. Nutter has called me. And so I would anticipate that the legal bills will plummet. At least that's my experience in working with him. I think that's been my experience in working with the Board of Education. So again, while I can't control any of you from calling me, it's my job to take your call, and I will, or other law firms will. The truth of the matter is, I think you might be better served financially, and also might be better served if Mr. Nutter could get the response out to the 5 of you to get those sort of questions. The third thing, this goes specifically, I think, to one of Mr. Kotowski's issues, board policy regarding the usage of board law firms. When Mr. Torrey and I reviewed Mr. Kotowski's original request, and I did that because, as you know, Mr. Torrey is part of your policy committee, I indicated to her I thought we had board policy on legal fees. She checked it, reported back, and we do not. I went through the minutes myself, and I discovered that we do. And let me kind of pass that out to you now, so you can take a look at this. And again, apologize for the old historical perspective. What's being passed out to you is a 2005 policy on Board of Education usage of legal fees. Literally a chance to take that. Curiously, this is not what your current board book says. And yet I went through and I didn't find any Board of Education action to revise, repeal, or otherwise adjust board policy 0153 and 0156 on the second page. Perhaps I missed it, but again, that would require, unless it was done by a 5-0 vote, it would have required at least two or three readings. As you can see, going back to 2005, a decision was made as to whether or not, for purposes of appointees, you wanted to use one or two lawyers or use lawyers based on the particular subject matter, which is exactly what you did. So you've chosen, and again, I believe this is still your board policy, while it certainly can be revised, you've chosen to employ multiple law firms for purposes of expertise, and which you've done in using them, which is your current practice today. If you go to the very last page, you can take a look. And again, for those of you who follow protocol, you'll see that these board policies were introduced at a particular meeting. They had their 3 readings, and they were adopted and approved. So, Mr. Torrey, it would be my opinion that unless we can find a revision or modification, this would be the policy upon which to work with, in taking some of Mr. Kotowski's suggestions as to how to use appropriately legal fees.
But these should be added then into our book if they're not there.
Yeah, I didn't see it in your book. I doesn't, I can't account for why not, but, and again, there may be, I might have missed it along the way. The other thing I think as we go forward with this is for the past 3 years at least, the organizational meeting every year, you hired 7 different law firms. And then there's a line in there, of course, that you use the county prosecutor where appropriate. It's a little bit ironic, I think, that others hammer the use of private law firms, and the Board of Education has actually authorized the use of them. But if you wanted to change that, if you wanted to limit the number of law firms that you deal with, or eliminate the number of law firms that you deal with, it certainly matters a simple board resolution, nothing more complicated than that. The next issue I wanted to talk about, and I'm going to do this carefully, is the issue of Mr. Palmer. You've asked me to respond to some of the issues because it appears that there's some discrepancies, rumors, and some concerns as to exactly what has occurred and how that came about. So I'll start out with generalities, and I may try to get more and more specific, if you will. And let's talk first of all about the cost of the separation agreement. I think, based on some of the documentation I've received, of all the issues surrounding the things I'm talking about, that seems to have a propensity to draw more concern. First of all, I don't have any idea why the cost of $150,000 is circulated. That's not true. Let me kind of walk through the numbers. If Mr. Palmer would have remained as your superintendent through the terms of his contract, and then retired, versus what he is actually going to be paid, I think you'll find that he left about $47,000 on the table. And let me kind of rephrase that. Had you remained your superintendent under contract through July 31st, 2015, and retired, you've been required to pay him actually $46,000 more than the separation agreement calls for. You can draw some inferences, perhaps, as to why he left $47,000 on the table, but the fact remains that that money is still there. So you actually are saving money on your superintendent by the separation agreement, $46,000 less. Now we enter an interim superintendent, Mr. Nutter. As you know, Mr. Nutter is being paid $5,000 a month. I'm not a mathematician, perhaps some of you are, but in my way of thinking, based on when he was employed, Mr. Nutter is free to this district until February 1, 2015. He's free because $5,000 times 9 months is $45,000 compared to what you would have paid Mr. Palmer. The worst scenario I can envision right now would be someone like Mr. Nutter continues on through the end of Mr. Palmer's year. That's an extra 6 months. The magic number would be cost you $30,000 more than you otherwise would have paid for a superintendent. Offsetting that $30,000 maximum would be, I believe, some incentive by both Mr. Nutter and this board to give Mr. Palmer some real relevant projects. Some projects that perhaps outside consultants would have been asked to do. Some projects that, not busy work, projects that are needed by the district. Things like job description development. I know Mr. Nutter mentioned You have some of the transportation scheduling issues that typically you pay outside firms. So again, I want to reiterate, Mr. Palmer is receiving his salary, and yes, that's a significant amount of money, but you haven't replaced him anywhere near the same amount of money. As a matter of fact, and again, I reemphasize that, you have $46,000 on the table, of which is 9 months of Mr. Nutter or someone like his salary, and the goal would be that the remaining cost of your running superintendent would be offset by finding projects, meaningful, relevant projects upon which you use an outside contractor. While we're on that topic, let's talk a little bit about hiring Mr. Nutter, and hiring Mr. Wilson, and then hiring Mr. Jones. And they're kind of all related. There appears to be, again, deliberately or otherwise, rumors and confusion as to Mr. Palmer's separation agreement. I personally have read some interesting things in the newspapers, and so maybe we can kind of set the record straight here. I think it's an absolute incorrect statement that this is what Mr. Palmer wanted. I wrote that in the paper. I think that's wrong. I don't think anyone out here thinks Mr. Palmer wanted not to be your superintendent. I think his first choice would be to remain as your superintendent and to stay here and enjoy a relevant and fruitful career, as he hoped to do when you hired him a couple of years ago. So statements that this is what Mr. Palmer wanted, I think are incorrect. Having said that, I think the separation agreement itself contains terms and conditions negotiated in favor of Mr. Palmer. And so when people indicate, was this what he wanted? No. For the terms and conditions of the separation agreement, what he wanted, I think that answer is largely yes. There are also rumors that one or two of you met in secret for purposes of negotiations of this contract and buyout, so we kind of set the record there as well. As you know, we received a call, or I received a call from the attorney representing Mr. Palmer based on events that were triggered. Without any direction from this Board of Education other than talk to him and see exactly what the cost would be, the attorney representing Mr. Palmer and I entered into discussions. No authority to settle, no authority to offer, but simply discussions. Contrary to what you heard, your lawyers did not draft a separation agreement. Didn't see it. That came 100% exclusively from Mr. Palmer's attorney. We made some modifications, tried to get some of the figures down, as we talked about. But I can tell you and let me represent to you that none of the 5 of you, not Mr. Gilroy at the time, had any input into that separation agreement. I think you need to know that. I didn't ask you what the parameters were. I didn't ask you what it would take. I went in and just had the best discussion I can, and I present it back to you. This is what Mr. Palmer wants. Is it enough or isn't it enough? Which is why some of you think that since you hadn't seen that before, that evidently you were the only one left out of the loop. Well, all 5 of you were left out of the loop. We did not have a meeting upon which you could give us any direction upon which to have a conversation and discussions. The figures you see in the separation agreement came from Mr. Palmer through his attorney. In fact, I even talked to Mr. Palmer. I talked directly with Kim Perry from BASA representing him. So I hope that kind of clears this up. The concerns that 1 or 2 of you met in secret, 1 or 2 of you negotiated this, gave marching orders, well, none of that happened. I think all 5 of you were surprised equally with what we brought to the table. And that also includes, of course, some of the issues that went along with it. When you negotiate and enter into a separation agreement for your superintendent, you need a plan. And one of the plans are going to be, well, who's going to be your superintendent? As you know, that's one of the few positions by operation of Ohio Revised Code you're required to handle. One of the things, again, that I was asked to do, one of the charges would be, well, what happens if Mr. Palmer agrees with separation agreement? What happens if he gets a job tomorrow? What happens if all these issues occur? And as a result, one of the tasks that I did for you is the same thing I did from trying to be treasurer for you. I went out and started calling people. In the case of the treasurer, that's kind of easy. Contrary to what you may think or believe, my first choice was not the choice in terms of ability. The first person that I asked was not, for example, Dan Wilson. It was someone else. And then when Dan Wilson decided he could no longer choose to work with us, both Mr. Wilson and I went a considerable list until we found Ms. Jones. Ms. Jones wasn't our next on the list, not because of ability, because we didn't know her. And both Mr. Wilson and I went through 7 or 8 different people. Are you interested? Are you interested? before she was referred to us, and thankfully she was, by a number of different people in terms of quality and ability. In a similar fashion, we need an interim superintendent if this separation agreement was going to work. Mr. Nutter was not first on the list. First removal, Mr. Nutter, you were fifth. The truth of the matter is there were 4 people who turned me down. I knew Mr. Nutter did not want to be a superintendent, probably the wrong thing to say. But the truth of the matter is, I was able to convince him to take this on for a 7-week assignment. I think we need to put that perspective in place. Mr. Nutter was only going to be employed through July 31st, 2014. You can probably decide among yourself why we haven't initiated a superintendent search yet, but nevertheless you haven't. And so I would anticipate that unless you can start a search, and unless you can complete it by the July 10th statutory deadline, Mr. Nutter may remain here a month or 2 longer. But in any event, he wasn't the first choice. He was someone who could help us fill a temporary gap. Also, contrary to rumor, I guess is the best way to say it, Mr. Thornton, Mr. Kilroy, where was I thought I saw it, Mr. Kilroy wasn't responsible for bringing Mr. Nutter in. As a matter of fact, Mr. Kilroy and 4 of you had not met Mr. Nutter, or 3 of you, Mr. Nutter, until the time you all met him together during that interview stage. The only one who had met him was the Vice President, Mr. Flory. And the reason we did that is I think some of you may remember at the time Mr. Kilroy was contemplating resigning from the Board of Education. As a matter of fact, you saw that he ultimately resigned from the Board of Education, but prior to that, he actually announced his resignation as president. So I thought it would be appropriate, since he's one way or the other is not going to be here either as board member or as president, that Mr. Torrey had that opportunity. I introduced them just basically for a job interview, and then again, Mr. Nutter shows up cold to the remaining board members, just as Ms. Jones did, perhaps to a couple of you, just as a couple of the others did. Here's an interim superintendent for 7 weeks if you want it. So while there was this conversation among the community, where did Mr. Nutter come from? Was he part of the plan to get rid of Mr. Palmer? Well, the answer is, yes, he was part of the plan because we needed a superintendent. Was the plan to exchange the 2? Well, no. If that would have been the case, I would have had my first choice here as a superintendent. The other issue then pertaining to both Ms. Jones and Mr. Nutter would be as we go forward. Currently they're both interim, and as I think we know, as we speak here, there's going to come a time relatively quickly where my recommendation to you would be that let's not continue with interim, particularly as we approach the school year for either of these 2 positions. The last one again, I'll hit this one, not the last one, the next one, would be another one of Mr. Katowski's issues. I'm not going to pick on you, sir, this comment. It's just a little bit ironic that I'm resisting giving you information only because when I do, it's going to cost me a couple $1,000 of your money to assemble it all, and you're going to hammer me over legal fees. But having said that, let me again advise the full board. Most of the information, not all the information that I've sent to any of you, including your administrative staff, has been to your WestGBrd addresses, your email addresses, which means any communication to you and from you, including your administrators, should be available for free if you want to contact Mr. Chandler. So I recommend you try to do that. The thing is, I've gone through, and I think I've indicated to Mr. Katowski by email, maybe all of you, I think it was a period of time where I had a few emails coming from Mr. Kilroy when he used a private account. When he was trying to, no offense, Mr. Kilroy, adjust the Google Docs with some of the others here, and I'll go through those. But by and large, every communication that any of you have received from me, you shall remain a recipient. If for some reason Mr. Chandler can't get that, because I'll address that to you, Mr. Miller, I'll let you know. But any and all communication, any and all information should be there. Any and all letters, any and all documentation. I also went through the file again in response to a request by Mr. Katowski. There were only 3 individuals that I actually sent opinions to. Your administrative staff, there would be the Office of the Superintendent, the Office of the Treasurer, and the Office of the Director of Student Services and Special Education. So you may find some documents there. Again, coming via email. If not, I would have some information there that I think I could provide for you. Lastly, again, some other Mr. Katowski issues. There seems to be some concern about an 8-year-old case called the Madison Plains case. And it should be of concern because it involved the removal of 3 board members. And so I thought I'd take a second here to talk a little bit about this. There's only 2 cases on record in the Ohio case currently. Madison Plains is one, Rock Creek would be the other. Madison Plains is familiar to me because they were my client. I had the pleasure at the time of being the school board attorney who had 4 board members subject to a petition for removal for 97 different allegations. So there's a lot of information in the Madison Plains case. It involves about 4,000 pages of transcripts and exhibits, an awful lot of testimony. It's a complicated case, and I'll be charitable in terms of how I present that. I believe there are some inaccuracies in terms of some of your suggestions. But let me start by saying a couple of things. I believe that there was concern that there was legal advice offered to board members that evidently did not help them at their trial. And there's a couple of things that's wrong with that assumption. One is you make the assumption that there was legal advice offered without any basis for that assumption. Number 2, you make the assumption that legal advice wasn't in writing. And again, that may be an incorrect assumption. I think all you can say by reading the appellate decision, and again, I recommend that you go beyond that and do the trial report, some of the transcript. I think you'll find that that was an allegation and a defense to an allegation that didn't materialize. Not only was there information in writing, that information in writing perhaps would not have been as helpful in the case as it should have been, which is why I think they wisely chose not to introduce it. So I think there's a mistake if you indicate that there was no legal advice in writing introduced at the trial, that there wasn't any legal advice in writing. The second issue there is, I think if you read again the trial transcript and some of the proceedings, I think you would have found that we had worked this out with the trial judge, that this wasn't going to be an issue that I would actually be able to testify. Which is what happened. I was released to testify, and then of course in the trial, unfortunately, they chose not to call me. And you can draw your inferences from that as well. But one thing I think you should know, and maybe this should give you some comfort level, would be that of the four board members, none were removed following advice of legal counsel. And so maybe I should have started with there and ended with that. But again, there's an awful lot of issues there. I think if you've read that, you'll see obstruction of justice, obstructing child reports, hiring people who turn out to be pedophiles, employing your wife 7 times in a row in 6 consecutive years. But fortunately, advice of legal counsel is not one of the issues. And you should also have comfort to know that the 4 board members, all equally having those sort of issues, one board member was not removed. So that should tell you again right away, they were not all culpable in terms of the advice that they received for the issues that they did. The next one's a little bit more serious. I guess I direct this to the 5 of you regarding issues, however, in your conduct and behavior. In the course of putting this together, I've had an opportunity to review a fair amount of emails, a fair amount of board agendas, and a fair amount of communications back and forth. And I think you see me repeatedly say, stop the emails. I think it's time to stop the emails. While you all may have an opinion as to sharing with other individuals, I think we all need to do a better job of understanding how the, quote, deliberations work. So I'm going to give you just a 3-minute presentation on those, and I think then we can kind of move forward with that. Emails are a form of communication. They're no different than in-person conversations. They're no different than telephone calls. Most people don't understand this concept of what constitutes a legal deliberation. If, for example, Michael, Tom, and Jackie were at Bob Evans, and Michael and Tom had a conversation saying, you know what, I don't like Mr. Nutter. I think he's a wrong superintendent. I think he needs to go, and I think I just don't like anything about him. And Mr. Torrey sits there and listens. We have a problem with deliberation. She heard your pros, your cons, back and forth. Her mind is now full of the deliberations you too. So it's a myth that if 3 of you are together, okay, all 3 of you have to talk. So keep that in mind, because when you send emails out, an email to 4 people, voicing your opinion, vote for this, don't vote for that, I like this, I don't like that, and one person responds, we've got a situation, it's not the third person, because 3 other people are listening via email to the deliberations of 2, and they're forming opinions, and they're forming ideas of how to vote. So the concept here of do we have exposure, only you 5 can answer that in terms of your emails. I haven't gone through all of them, but I will say that we need to do a much better job in terms of going through email. The second issue is do we have exposure, I think we need to bring up. There are some rules, and I'll make sure now that we have an appropriate treasurer in place, that everyone understands those rules as to how you go into executive session. The rules of executive session are cast in concrete. You don't go into executive session in a haphazard way. You don't just say, for example, I'm going into executive session to discuss personnel. There are 7 different reasons under personnel. You need to list one of them. And so again, as I've been going through some of these, the good news is I haven't put anything together that will cause any gates, an otherwise lawful resolution. But I do have some concerns. I think we all need to do a much better job of making sure executive sessions have a proper statement in terms of Ohio Revised Code 121.22G1. And we need to not shut down emails, at least try to eliminate opinions in terms of how you intend to vote, something that an outsider could construe in terms of going forward for deliberation. To specifically answer your question that you raised for me, to the Geauga County prosecutor had the opportunity to review all 5 of your conduct and things that you've done. I would caution you with this one, that the Geauga County auditor, the prosecutor, has a statutory duty, if you will, to prosecute all actions against a board member for malfeasance or misfeasance. So the point would be, if the Geauga County prosecutor finds something that any of the 5 of you did individually incorrect, they're going to statutory duty to proceed. I do believe that you would have little to worry about, Mr. Kotowski, in terms of things that Mr. Kilroy has done, or Mr. Olson has done, Mr. Torrey, Dr. Phelps, or also Mr. Douglas. So one put your mind at ease of that. If you wanted some individuals to review, my recommendation to you would be not to have the county prosecutor do it, but to engage a private attorney, give you some peace of mind, who an attorney-client privilege to more appropriately advise you as to the conduct of your colleagues and also the board. I think I'll stop there. I think I've covered a little bit of what you've asked. I think I've probably taken too much of your time. I may break my opening rule. I won't be taking questions. Maybe I'll just use this for a couple of minutes. If there's just 1 or 2 questions that you might have of general interest, maybe I can respond. In particular, if I haven't addressed what you wanted me to address, I think that goes for you too, Mr. Kowalski.
Well, that's why I would love to have you recognized, Mr. President.
Absolutely.
Thank you. The first thing is on the prosecutorial review. Actually, that had nothing to do with conduct. It had to do with certain resolutions we passed. And it has to do with Madison Plains. Madison Plains had nothing to do with you, specifically, in what I was citing. What I was citing is, in Madison Plains, and you don't need 4,000 pages of testimony to read this, because what you want to read is what the judge said the law is. And this is what my concern was looking at Madison Plains. Madison Plains set very severe limits on the board's authority. The board only has authority when it's in session, and the board only has authority as an entity, not as individuals. And that was one of the findings that was repeated by the judge a number of times in that case. And so what I wanted the prosecutor to review, we have had various resolutions on the part of this board where we're assigning certain power to the board president, for instance, to increase hours of a superintendent or a treasurer. My resolution on controlling legal expenses suggested that the board president, when there were emergencies where time of work is of the essence, the board president should be able to authorize the use of legal services. So the question that I wanted to pose to the prosecutor was not on the conduct of board members, but rather it was a policy question. Do we have the ability to delegate, given that Madison Plains says we don't know how far that prohibition extends?
Well, I could answer that question. There's probably little use in me doing so. So we can decide when we want to use the prosecutor to answer that question. Anything else?
Yeah. one more, let me check my notes.
Make it good.
Yeah, you've, frankly, John, and this is one thing that does have to do, I think, with you as our attorney, very specifically. This, again, is something which I was concerned about after reading Madison Plains. And again, this is not about you in Madison Plains, because it appears the reason they didn't cite your legal advice is probably because they didn't take it. But what
I
we
can't
have,
comment on that. I thank you for your insight.
well, Don, what we've got, though, is we've got quite a bit spent on legal fees, and we virtually never get anything in writing from you. You talk to people on the phone, and then nothing shoots out to the entire board so that we know what's been talked about. We get it secondhand from a board member and so on. And so my concern was in Madison Plains, it was pointed out that the fiduciary responsibility of the board member is to listen to the expert advice they get. And in this particular case, we're talking about legal advice from our attorney. Now, in Madison Plains, they couldn't show anything. Now, it doesn't matter for our purposes whether it was because they didn't want to show it or because they couldn't show it. Because in the case of WestGBrd, we have very, very little in writing from you for all of the talking we've done to you, with you, for all of the exchanges, for all of the things that have been going on, for $30,000 in 6 months. I mean, that's a lot of legal advice, and I see almost nothing in writing. And I would like to see it in writing so that this board is protected and so that every member gets the same information.
Oddly, I'm happy to do that. It's much more expensive.
Yeah.
And I don't say that sarcastically, but it means writing.
No, but it seems to me that as board members,
I think if you go through the bills, and clearly you have, I want to make sure we draw a distinction between legal advice and legal representation. For example, when I bill you for 10 hours of sitting in negotiations, don't expect an email. And that's probably the most expensive thing that I've done for you this spring. When I review your agenda and make suggestions and corrections, and I've done that, as you know, consistently, what you get is the agenda. When I get a phone call that says, how do we phrase that happened today? How do we phrase an item on the agenda? What you get is how to correctly phrase that answer. Now, I'm happy to reduce every conversation writing. Again, it takes longer to write than it does to speak. But I don't want to confuse the issue that there are $30,000 of legal opinions floating up there that everyone on the board seems to have been privy to but you. But I'll be happy, and I mean this again, not sarcastically, to put a lot more things in writing, although I suspect, starting with July 1, that opportunity is going to diminish significantly with your new superintendent.
yeah, and I do want to say, John, that my criticisms of our legal fees are not criticisms of you, because this is what the board has asked you to do.
Thank you for that.
So it's merely a statement that the board is not being responsible with spending.
Yeah, I do that. My relationship with you, I never doubted for a second that this one didn't. Thank you for saying that.
I do have a question based off of what Mr. Kowalski just said. Because I haven't seen the numbers of history, if you will. And it's funny that you asked about the legal advice of the last 6 months when you and I were both elected 2.5 years ago. And I've never seen legal advice from $36,000, $31,000. Have you?
No, and I've been asking for it even before the new board was
But
elected.
I think
even
it's
before the
irrelevant for you
election.
to
I've
just
been
say
asking
this
for these things.
$30,000. You might as well just say you haven't received it in 2.5 years.
Well, I could just as well say that. Frankly, though, if you look at this, we're looking at $30,000 in 6 months. Now, go back 2013, $15,000 in a year, 2012, $36,000 in a year.
It's
I mean,
irrelevant
Jackie,
if it's $12 or $30,000. Have you received in 2.5 years what you're asking for, what you haven't received in 6 months? It's not just this 6 months you haven't received it. You haven't received it in 2.5 years, correct?
Right, absolutely.
Okay,
And
well, then
I've been
let's
talking
make your
about
statement correct.
it practically since I was on the board.
And
so
again, going
it's something I'd like to
forward,
see.
okay, going forward, my recommendation would be that we take Mr. Kowalski's suggestions on legal fees in the context of lawyer. We have a policy committee. It'd be really nice if we can back the structure.
Yes.
But a policy committee, which I think is composed of the superintendent, Mr. Torrey, our treasurer, and our legal representative from Neola. A policy to go with. Let's take Mr. Kowski's suggestions, let's see what recommendations they come up with, like we do with every other policy. They're good recommendations, suggestions, we should incorporate them. Neola, as you know, represents draft policy for along the Ohio School Board, almost every school district. They've got that sort of wealth of information that I think you're already paying for, by the way. There's a policy.
My question might be in just sort of learning curve, if I may. Mr. Kudowski has recommended the prosecutor. The advice that we get from the prosecutor, we don't pay for. That's free advice?
The advice you get from the prosecutor is free advice. The situation, and again,
worth every cent.
Pardon me?
And worth every cent.
Worth every cent, yes. I'm going to tell you said that. There are some things they won't do, and that's always why boards of education and on-site counsel.
Such as?
Negotiations. They don't do. They don't do issues typically where it involves parents, special education issues. They do an awful lot of policy development, if that's the direction we want to go. They will represent you, and I think in our next issue that we're going to talk about, we may very well conclude, let's let the prosecutor, if we don't resolve this today, handle that. Having said that, as good as our Geauga County Prosecutor's Office are, they don't have the staff to assume full-time representation to the 7 local school districts in the state of Ohio, in Geauga County. There's always been an understanding among the superintendents, use the prosecutor. There's some things that they're good at. If they write an opinion, for example, on open enrollment against them, there's no reason you can't have that same open enrollment policy for free if it works for you. So sometimes you don't have to reinvent the wheel, and there's a lot of good things by a representative, Sheila, for example, the prosecutor's office, is really good at helping things out. It's simply a matter of our superintendent and treasurer asking the prosecutor's office, is this something that you can do for us? And just as importantly, what's the time for it? Because it's always been that way. We don't keep track of the amount of money we save from the prosecutor. Maybe we should. That might be an interesting statistic. Maybe they keep their own for us. But yeah, using the prosecutor's office is always a good idea. And I was a little bit surprised when Mr. Kowski informed me that we haven't been. Because again, this isn't anything that we've been using for the past 4 years.
Sure. I appreciate you doing this. I know this wasn't necessarily easy. The last board meeting that we had, there was a number of items that came up, both from the public and from the board, that pertain to you. I wanted to give you an opportunity to address those things, and I'm glad that you did that.
Well, I appreciate that. I guess I have the next item on the agenda.
Absolutely. Excuse me, though, I haven't. Do you gentlemen have any questions? If you don't mind, I mean, we've kind of monopolized this time. Just one. Anyway, do you gentlemen have any questions regarding where we're at, or where we've come, or where our future might be? I think I can speak for myself in that in the short amount of time that I've been board president, we haven't spoken very often other than my first meeting, and I felt pretty confident in the superintendent, the interim superintendent we've had, to bounce those ideas off. And a certain amount of communication and trust are inherent with that role between the board president and the superintendent, of which, for me personally, I felt very comfortable in doing so. So I think going forward, for the public, as you look at those large legal bills, I think you will see them drop off drastically from this current board and as we proceed forward. So then, to your point, who will be able to talk and who won't be able to talk, I hope that we could, as a consensus, look towards the superintendent to make those judgment calls. And of course, from that standpoint, if you're not satisfied with those answers, we'll collectively discuss it and then take it to that next level so that it isn't $60,000 or $70,000. I'm a little concerned is where the other $14,000 came from. And if that's the standard, or if that's something we do, because these numbers that you had before, I mean, I think, did we pay for attorneys that were fighting against you? In any kind of, I'm serious, you know, I don't know. I mean, who would have contacted these $14,000 of attorney fees?
Truthfully, again, we use attorneys for some very specific purposes. A few years back, we hired the law firm McDonald Hopkins, who helped us out with natural gas wells and drills. I'm thinking of people on the board. We do have situations when we do use attorneys that specialize in capacities. I think we use attorneys, for example, on some tax valuations. When you have bond issues, by statute, by the way, the prosecutor does not do that. I think Smarty Sanders is the one who does our tax work. So people on that firm, people on that list typically have a special. Now, let me go out on a limb and maybe give you some comfort. I say this with over 300 monthly bills in my basement to WestGBrd. if you let Mr. Nutter and Mr. Jones do their job and ask the right questions, there isn't any reason that your monthly bills shouldn't be $1,200 each month. It makes it $12,000 to $15,000 a year, which is historically where we've been. The exceptions to that are negotiations, special ed, or something that Mr. Nutter can easily point to. Here's where we're going.
The exceptions are 2011, 2012, 2013, and 14. I mean, they
Well,
considerably.
Times are changing, but again,
Okay, I think we move on to our next item.
we have a piece of litigation. As you know, it's unusual that we talk about this in open session, but it's come to my attention that this is Facebook, Chester News, and a couple
Well,
others.
quite frankly, this was something that I wanted done.
Okay,
Because
and that's
it's an
fine.
act of transparency, for lack of better terms, or just what are we accomplishing, what are we doing? I really felt this was important to discuss.
Okay. The only reason I'm going to hesitate, because at the end of this, I'm going to recommend we give it to the prosecutor's office. And so I'm hoping that he will appreciate the fact that we're now going to sit here and discuss this case in front of about 50 people. But nevertheless, back in the summer of 2013, we had the meeting to develop a job description, Director of Construction Technology. Has Brendan been here? It's Brendan job description. In this technological age, of course, there's no such reinventing the wheel. Our administrative staff went online on a couple of policies of the job descriptions in place that seemed to fit our unique needs here at WestG and incorporated those into the WestG job description. Late fall, we received a letter from an attorney representing a group called Whittle Consulting, informed us that the information that we borrowed online from various public school districts was copyright protected, and there's no cease and desist at that point in time, asking for damages, asking for money. Board of Education at the time had an executive session. Since there's only two of you in that executive session and not released to talk about it, we did discuss the possibility of a settlement agreement. We weren't asking for a lot of money, and we thought that we could try to incrementally make that happen. We hit the authority of that executive session in terms of settlement agreement. They wanted a little bit more money, and picking up a lot more money. And so we ended up with a private lawsuit against the Board of Education in federal district court. We had a conference call with the judge, and a couple of interesting things happened. Federal judge, a little bit of power over how we had courtrooms maintained, and both sides got a couple of direct orders. One would be they're only really asking for $6,000. This is not exactly what the federal court was designed to settle this for $3,000. And so I don't have the authority to settle this for $3,000, but that's what a judge wants us to do. I have to talk to the other side to see if they're willing to do that. You'll recall we have $2,000 on the table, and so they want to do $3,000. We contacted our insurance company, and I don't think, as of today, they got back with us yet. Okay.
I left him.
Okay, well, I'm sure. The bad news of your insurance company is getting $2,500 deductible. So they would take it, okay, you pay the first $2,500. So the insurance company picks this up, you can certainly question the issue and fine. The issue, and I think, Ben, this is a perfect issue for discussion, would be, you don't litigate a case like this for $3,000. You want to turn it over to the prosecutor, that's great. The prosecutor, the federal judge, I don't think that anybody say no. But your choices are relatively easy. We have a little bit of time. And this may be something perhaps that Mr. Nutter could actually contact the prosecutor's office to see if there's that sort of interest. But again, a strong encouragement from our federal judge to settle this matter for $3,000. You can't litigate it for $3,000. Your insurance company picks it up, you pay the first $2,500. If they don't, then you'll do $3,000. The prosecutor may indeed assist you without explaining legal fees, and let you end up with further matter with the judge. The judge made me promise, and I need to say this to you, that the first thing he's going to do a pre-trial, if you want to settle this, is call all 5 of you down there for the day. So you get to meet him personally.
All right, so just in discussion, our superintendent plagiarized a job description. From that job description, we're being sued.
I don't think the word plagiarize is in the litigation. There's copyright infringement, meaning there was some protected work,
Okay,
and they think happens there.
okay.
It's not an easy body of law, copyright infringement. I've had a conversation with a couple of people I consider experts in the field. The recommendation that I've received when they were prosecutor, I'm sure this would be a little different. I don't know that means anything inappropriate. There's a whole different.
Being sued for $6,000 for what we didn't do inappropriately. I mean, honestly.
You can always
receive a settlement.
It's
Okay.
you know, and again, it's, the issue here would be, you know, can we resolve the issue? I will say that we probably, I think I know the direction you want to go. Feel like you guys didn't do anything wrong?
No, I didn't ask
Okay.
that question. I mean, you know, thank you. I appreciate the way and the manner that you conduct the information. However, I'm just sort of matter of fact. I just want to make the decision based on, and again, I mean no disrespect, John. I just want to be clear as to what we're deciding here. We looked to settle this before it got out of hand. They didn't accept our settlement. We're at a different dollar amount today. For $3,000, this is what the judge has recommended. We can pursue, say that we're right and fight and go to court and trial, or we can settle this for $3,000. So we have to make that decision. But the decision that we
Well,
have
again,
to make,
it's a decision to offer. I want to caution you.
I understand.
Okay.
I understand. We can look to the prosecutor to go for a more favorable view of what's been recommended by the judge who appeared in this case. So, yeah, you know. Yes, Ben.
It's not just to look for a more favorable resolution, it's that the prosecutor will do it without us incurring any fees, and Mr. Pogierski would have to continue billing us. That's the point. We may get to the same place that we get with Mr. Pogierski, but there wouldn't be fees. And in fact, if Mr. Pogierski saved us, say, $500, we'd still be in the hole compared to having the prosecutor do it. Is, I think, kind of where we're at.
And actually, again, I have a historical perspective.
Yeah.
Typically, when we were sued, that's what happens. We turn this over to the prosecutor. You know, we
Can I
initially.
ask you for just pennies? Is it silly to even take it to the next step with the prosecutor and not just offer the $3,000? I mean, are you dragging out something that's inevitable?
Yeah, it's a real good question. Let me kind of put it another way. Will we prevail if this lawsuit goes forward? In my professional opinion, I think the answer to that question is yes. Is that worth going forward for? I think that's your call. I think that there may have been some errors in judgment. I think that there may have been some things that perhaps could have been different in the design of the job description. I do not believe that according to the federal laws of the United States, that we have violated copyright laws. You're the others that I approach this matter with. So at this point in time, being right is fine. On the other hand, we are being sued in federal court. And even if the prosecutor takes it, there's going to be a fair amount of time that you and your staff have to develop in terms of defense documents, exhibits. Mr. Kyle would be one, of course, of I imagine several. And again, just you need to direct it to the judge. Again, you don't have to necessarily decide this decision tonight, but I really recommend, and the reason I have a resolution here, is that you recommend that Mr. Nutter contact the prosecutor, probably hasn't seen this, let him know the prosecutor has to, let the prosecutor know the judge would strongly encourage settlement, let him know the dollar value. I could certainly follow that up with a call to the prosecutor, inform him, negotiate to date, share some research with him that's already been developed, and then you would give the prosecutor authority to sell this for up to $3,000 on your behalf if he thinks it's appropriate and necessary. Otherwise, if he wants to fight it, well, that'd be his call.
Can I ask you,
Yes.
do you know who the prosecutor would be in terms of federal judge?
I know the federal judge, sure, Holster. Who the prosecutor, I guess it's Sheila, although maybe not. Copyrights are rather tricky things for other individuals. This is not necessarily a school law issue. There is a law firm that we deal with on Brookfield Network. They're a specialist in this. And, you know, we can inform us now that they're pretty good. So we decided we're going to go forward with this. The prosecutor has developed a can he can draw upon it.
I'm gonna ask Mike, again, your experience. I mean, is this something we settle? Is this something we send to the prosecutor? What would your opinion be of this?
Well, they're happy, so I'm experienced
All right.
in this as far as, but you can take it to the county prosecutor, I don't know if they'll take it. Will they take it?
Well, they'll take it, because by
When?
statute, they have to take it.
I mean, when will they get to it? I mean,
Well, again, we've got a great relationship with the prosecutor's office. What they'll tell us is sell this for 3,000, or we'll take it forward, just that simple. Again, there's always a risk, when going to trial. You should know that a violation of the federal copyright laws do have payment of attorney fees and it prevails, which means you not only pay your fees, or even though the prosecutor is free, you go to trial and lose, you have to pay their fees. At least they can ask for fees. One of those few exceptions was the American rule of welfare, so that possibility exists. I guess the prosecutor can decide if that's a real threat or not. But again, I would guess that the prosecutor is busy. I would guess that the prosecutor would probably indicate, this is a sort of issue that can be resolved. Just because 3,000 is what the judge suggested, doesn't necessarily mean the plaintiffs will take it. You could offer something less, 2,500. We talked a little bit about having this company, an educational consulting company, Widow Consulting, maybe some of you heard of the name, maybe do some work for the district, earn some money. And that would be a possibility too. So there are ways that we can reach settlement on this. My point would be, I think the limit, what you gave me in the executive session, that I need further direction. Or the prosecutor needs further direction.
Right.
if you want, I can contact them, it's free.
Do you guys have any questions? Do you have any? Because I'm just assumed, and we can vote this up or down, to make the motion to allow them to settle. If $3,000 is what's on the table, or being strongly suggested to be on the table, I'd like to just button it up. How far do you want to go? Now, if it goes, well, let's discuss it. I make a motion that we authorize John Paderski to offer $3,000. What's the name of the firm, John?
Widow Consulting.
Widow Consulting
That's
as a settlement. Do I have a second? All right, this is discussion. I think that at this stage of the game, I mean, we're $3,000 and what's the offer by a judge. I don't think, if it goes, he's strongly suggesting that $3,000 is what we should all settle for. If it goes any further, then perhaps we look at the prosecutor to do it, because he's going to have a conversation that he's going to bill us for with the prosecutor to tell us where we're at. It's just as soon as him making the offer, in my opinion. And so we've already spent the money. Have him make the offer. If it goes further, then we'll look at the prosecutor, in my opinion.
Yeah. Actually, Dan, the reason I'd like to see it go to the prosecutor is, for one thing, probably the judge will then delay to allow the prosecutor to get up to speed and so on. The longer it's delayed, the better for us.
That won't happen only because
That
there's been
won't
no
happen.
answer yet. It's too early. We still have another 30 days.
Uh-huh.
So if we're going to do the prosecutor, we should do it in a hurry. But
Yeah.
I don't think we're going to get a delay from him. Although the prosecutor can certainly ask for one.
Yeah.
Typically what happens in these things, as you know, do the selection of the audience. In this particular case, the lead answer file. Because it's illegal litigation, the judge will set a pre-trial conference. So the answer is relatively straightforward. So there's plenty of time
Yeah.
for the prosecutor. However, if we're going to get the prosecutors in at some point in time, always in the theory, the prosecutor should be on some offer. You can do it any way that you want to. Sometimes when you make a settlement offer, Mr. Mandel's attorney, there may be others, you get a sense as to who you're talking to. So, I think if you want to settle this, that's fine. The question is, who makes the offer to settle this?
Yeah, so basically, would you have much time in making that offer and then seeing to it that if the offer is accepted, that everything is drawn up as it needed to be? I mean, would that be additional expense or down?
Here's what happens. That'd be a 5-minute conversation with their attorney. They'll get back to me and say yes, no, offer. If we have it done, then typically the attorney draws what they call a voluntary dismissal with agreement, as opposed to loss. That's what I'll propose. So Either way, it's not particularly expensive. The expense to you will be if the $3,000 offer is turned down in terms of next step. Right now, we haven't answered the complaint. We haven't gone through, as you know, the required paragraph by paragraph, state cause of action, state defenses. That hasn't been done, and that's probably the first initial cost of any litigation.
Yeah, well, so we haven't encountered that fee yet,
No,
right?
I haven't done that.
And so, if you were, if we did send this to the county prosecutor, you would have to brief them and send them your records and so on, and meet in person there, or?
Yeah, although it's not that complicated, they're pretty experienced litigators.
Yeah.
This is not particularly complicated. The complaint, a couple letters, gone back and forth from attorney and conversation. Let alone the status called the judge, probably all of the experienced litigators.
Yeah, which basically, if the offer was turned down, if you made the offer and it was turned down, you'd still have to then do that. We turned it over to the county prosecutor to take it from there.
Yes.
You'd still have to.
Yes.
So, Dan, we'd be taking the chance. I mean, I can see what you're saying. If we could get it over with now, it'd be over and done with. On the other hand, we're taking the chance that if they would refuse our offer and we'd have to then incur additional expenses to turn it over to the county prosecutor. So it's,
That sums it up. Roll call, please.
Mr. Thorson?
Yes.
Mrs. DeTore?
Yes.
Mr. Douglas?
Yes.
Mr. Katowski?
yes.
Dr. Phelps?
Yes.
Okay, item approval agreement with Madison Local School District to provide interim treasurer.
What do you
I'm
need?
sorry. I would like to thank you for taking that time, and I would like to excuse you.
Thank you.
The meter's on. Thanks, John. We're moving to approval agreement with Madison Local School District to provide interim treasurer service through July 31st, 2014. Do I have a motion? Do I have a second? Madison's been kind enough to allow us to hold on to Shauna one additional month. And Shauna, thank you so much for working through some of this with us. And so I'd like to take advantage of that. So I'm definitely in favor of this. Any discussion? Roll call.
Mr. Douglas?
Yes.
Mr. Thorson?
Yes.
Mrs. DeTore?
Yes.
Mr. Katowski?
Yes.
Dr. Phelps?
Yes.
Great. So the treasurer's recommendations.
Okay, my recommendations is to approve final appropriations for fiscal year 2014, to approve temporary appropriations for fiscal year 2015, and to approve the following advances, all from general fund to Fund 006 food service in the amount of $51,084.20, to Fund 5006 Race to the Top, $51.49, Fund 516 IDEA 6B, $6,505.93, and Fund 572 Title I, $9,974.43.
Do I have a motion? I'll motion. Do I have a second?
Second.
Any discussion? This is pretty standard, right, Shauna?
Yes,
I mean,
yes.
okay.
This happens at every end of fiscal year, then your appropriations have to go to your county auditor.
Great.
So, Sean, the 51,000 food service,
Yeah.
is that basically we're funding them and then the money is going to come back into the treasury as students buy lunches and so on, at least to the extent that it does?
Yes, these are advances.
Yeah.
They're not transfers.
Right.
So they will come back to the general fund. Okay?
Okay, roll call.
Mr. Thorson?
Yes.
Mr. Douglas?
Yes.
Mrs. DeTore?
Yes.
Mr. Katowski?
Yes.
Dr. Phelps?
Yes.
Okay, standing committee discussions. I don't know that in the last week we've had many committee meetings. Has there been? Have you had any discussion?
No, I've been informed that the policies, hoping to get back with Tim to be able to implement that. We'll be going through our lengthy first readings at the next board meeting, and hopefully we will get a response from Tim from Neola on those their policies that
We also have to look towards filling these committees, and I'd like to sort of hold off on that, only in that Mike and I want to have some discussion as to how we continue you know, how we continue the organization of the board, if we're going to continue in that fashion, or utilize some ideas that Mike has had with previous boards, and I hope that we're in agreement to see what that might look like. And, you know, certainly we can continue, or we can do what some other boards have done and see how it might work better for us. So, with your permission, we'll go in that direction.
I do want to have
Sure.
a meeting with the curriculum committee. And it might be one that additional board members would want to attend because, you know, the third grade reading guarantee has been somewhat controversial, and there are things that we're doing to adjust to that which board members should be aware of. The transfer of teachers, policies on retention, how well we've done compared to other districts, and also what curriculum we're using to accomplish that. And I think the board should really spend some time delving into that, and whether we end up holding a special meeting or simply take a segment of a regular meeting and do that. So I think it's, you know, a really critical thing about what's happening, because it's a gigantic change, and parents have been concerned about it, and it's going to really affect our kids too.
I think it would be, Nancy has presented to us before at board meeting, and the only reason why, I'm certainly not against if more board members want to come to a meeting, but if everybody can't meet, again, we've had this issue before, if only 3 can come, you still have to inform the other 2 about it. So, you know, maybe still presenting it at a board meeting is still
Yeah,
beneficial.
and it might be good for the public too.
And the community,
It's the kind of thing that, you know, we might want to get out with a press release or something, because some parents are really concerned about this. So, you know, maybe we do that and give Nancy a chance to, you know, inform the community. You're nodding good. Okay, for the record, Nancy Benacosta is nodding.
Certainly, if you'd like to do that, just let me know.
That would be great.
Dr. Phelps, anything on personnel committee?
No.
Okay. And basically, the finance committee, we did a lot last meeting with that regarding what we just did part of this meeting with the church. So I'll have some more things to prepare to bring up at the next meeting, as at least with that about it.
We can look at, like I said, we can look at some different structures as far as the transfer factor, third grade reading guarantee, in terms of transfer issues.
Superintendent's recommendations?
We have personnel. Personnel, these are fairly standard as well. We have resignation, we have somebody moved up on the contract from regular to continue. We have some supplemental assignments. We have promoted. We have some more ESY extended school year. We have athletics. Pretty much it.
Yes,
Try
Dr.
to- In the future, we're going to try to, it's my goal, it would be the goal for the district to have their fall coaches hired in the previous school year. The winter coaches would be hired during the summer, and preferably spring coaches hired during the fall. So,
Have we not used that practice here, to your knowledge?
that's my knowledge. Well, I'm hiring coaches right now that are coaching fall sports.
Give me a little more streamlined.
Donations to the district, $3,000 donation for the middle school volleyball nets, and from the athletic boosters, and received $450 donation from the GE Foundation Mention Gifts Program for high school science and technology. We also have a bus purchase, and there's a letter attached to that, so we're buying a bus and replacing a bus.
I'd like to have some discussion with that as to where that money's coming out, but we can talk about it another time. Okay. I know it is. There's other line items that I can go to as well, Mr. Rousseau, and we can have some discussion as to where that might come from. Yes, sir. Thank you. Appreciate that. You know, Mike, you and I have had some discussion too regarding some meetings that you've had. Is this an appropriate time to put this in this agenda? Just, I think it's an excellent, it's an excellent program. Can we do that? Being that this is a special meeting, this is one of those times I don't need an attorney to ask a question. But
Program for such as
the extracurricular, the activities for like latchkey that we talked about.
yeah, no, we won't. I'll bring it up because we won't add anything.
Okay. No, I didn't think so. Okay.
No, I'd like to talk about it. There's nothing wrong with talking about it. It's good for the district. We can bring that up. After you guys.
Okay. We wanted to make a special recognition, and of course, we didn't have this necessarily in our minutes, to Deb Marino. Deb, you've had 13 years of service. This is your last day. Kind of sadly, we wish you the best of luck. I understand that Cardinal part-time is in the future. Well, they'll be very fortunate to have you. But we have, up here, if I can have you come up here, please. Thank you very much for your years of service. And we're sorry to see you go, but wish you the best of luck. Thank you.
Make a motion to
Second that motion. Roll call. I'm sorry. Roll call.
Mrs. DeTore?
Yep.
Mr. Douglas?
Yes.
Mr. Katowski?
Yes.
Dr. Phelps?
Yeah.
Mr. Thorson?
Yes. Okay, I move to go into executive session. Announcement of our next board meeting. Our regular next board meeting is July 21st, 2014. It will be in the community room. There will be a spot for public comments if that should be necessary. And also, it will be a regular board meeting. I move that we go into executive session. Do I have a motion? I'm sorry. For ORC 121.22 G1, employment of treasurer. Do I have a motion? In a second? Roll call.
Mr. Thorson?
Yes.
Mr. Douglas?
Yes.
Mrs. DeTore?
Yes.
Mr. Katowski?
Yes.
Dr. Phelps?
Yeah.
Put on some black at the end and
My name is Rick Snyder, 8230 Fairmount Road, Chesterland. Actually, what I'd like to do is just follow up pretty much